I would object if he has two previous domestic violence convictions from 2023. In this case, he pinned the victim to the ground, put his knee to her neck, and punched her in the head. She had a front back neck. He also grabbed her by the shoulder, spit at her, along with pushing her around the house. So given that, I would ask for bond remain as set, Your Honor.
And did your name, sir?
David Childs.
Thank you.
I'm sorry, Your Honor, Mr. Childs just said something. Could I get clarification?
You may want to hit the button so we don't have to ready to go.
All right, thank you, Your Honor. Okay. At this time, my client wishes to waive the preliminary examination. He's going to sign the waiver form right now, and we'd like to address bond.
Yeah. Is there a reason all my informations are missing? Like the second file. Sir, you're waiving your right to a preliminary examination?
Are you waiving your right to a preliminary exam, sir?
Yes. You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them. You understand you'll not have that hearing and that you'll proceed to circuit court.
Yes, Your Honor.
For further resolution. People also waive their right. Preliminary examination having been waived, defendants bound over to circuit court on both counts.
Your Honor, we acknowledge receipt of the information. Wade, it's on the record, and at this time, my client wishes to stay on mute and have the court enter a not guilty plea.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for April 7th, 2026, 1:30, Judge Conkey. As to bond.
Your Honor, we're requesting that that the court would consider one of two options for Mr. Childs. The first is to grant him a personal recognizance bond. He has been in custody for, I want to say, 2 months at this point.
Longer than that.
At least 2 months at this time. He is a small business owner. He owns his own flooring company. He can return to that work. He can be released on tether to the address in the file and has no problem with the no contact order or a no go to that area order. Part of the reason for my confusion or not being quite clear about his dates is because this case is a reauthorization case. However, the original felony was reduced and was pending in district court up until yesterday. So with that, in terms of the total time with regard to these incidents, it would be more than that.
Response.
This case is right. This is a reauthorization. It originally was an exam and was remanded. However, right after they reached out to let us know that she hadn't made that court date or wanted to participate and was still scared of this defendant. She was present today. We talking about it. He was waiting. I would object if he has two previous domestic violence convictions from 2023. In this case, he pinned the victim to the ground, put his knee to her neck, and punched her in the head. She had a front back neck. He also grabbed her by the shoulder, spit at her, along with pushing her around the house. So given that, I would ask for bond remain as set, Your Honor.
And did the previous, are they involving this same individual or no?
Yeah.
I do not believe so, Your Honor.
I mean, I don't know that either one is good, but anything else, Ms. King?
Our alternative request would be a release to substance abuse treatment.
I don't have a problem signing release to substance abuse or inpatient treatment.
Yes.
And so if that order's prepared, I'll sign that. But as to the changing of the bond to a personal recognizance, that motion is denied.
Would that be with the tether?
It would be with the GPS tether. That's
right, thank you.
Thank you.
Mr. Morgan, who is joining me at the podium. Mr. Morgan, would you state your name for the record?
Each of his cases, I have before me a plea form that indicates that he's going to plead no contest to in the case ending in that 5820 or 5320. He added count 4, counts 1 and 3 would be dismissed. And in the other matter, he would be pleading to an added count 2. Both counts are aggravated assault. There is further a sentence agreement and no upfront jail. That's the court's full understanding of the agreements.
The defense agrees. Thank you.
And haven't sworn.
You solemnly swear to affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
State your name, please.
Shane Morgan.
Okay, Mr. Morgan, it's this court's understanding. Back assault. Those are misdemeanors punishable by up to 1 year incarceration and $1,000 fine plus court costs. Do you understand that, sir?
Yes, sir.
You understand what a no contest plea is?
Yes, sir.
2 things about a no contest plea I have to make sure that you understand. First is it means that you're not further desirous or wanting to contest these charges. You understand that?
Yes, sir.
Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that, sir?
Yes, sir.
You understand, sir, that although I'm taking your plea, I would not be your sentencing judge. And in the case ending in 5820, you would be sentenced by Judge Garwood. And in the other matter, you would be sentenced before Judge Perry.
Yes, sir.
You understand that, sir?
Yes, sir.
Basis for the no contest, please.
Lack of memory.
Sir, to the charge of aggravated assault as contained in the case 5820, how do you plead?
No contest.
To that same charge as contained in the other matter, so it's at 55, can't read their writing. 5535. 5535. How do you plead?
Guilty.
Or
No contest. No.
You understand that by pleading no contest, you will not have a trial of any kind.
Yes, sir.
You signed an advice of rights form in each of these cases?
Yes, sir.
Any questions regarding any of those rights?
No, sir.
Let's look at paragraph 5. There's a copy on the podium.
This is the same form you said.
Those are your rights, which are part of a trial. You understand by pleading no contest, you're giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily and of your own free will?
Yes, sir.
Court has been provided and has reviewed Ann Arbor Police Department report for their case number. Let's get to it. So, no. Close it out and put it back. Actually, it's University of Michigan Department of Public Safety for their case number 2590304546. And in the other matter, University of Michigan Department of Police report for their case number 267326. Any objection to the court having reviewed those reports?
Thank you.
None from defense.
Based upon a review of those reports, the court does find that there's a sufficient factual basis in which the court could find a defendant guilty of these offenses. Sir, I do have to advise you upon me taking your plea that if you commit misconduct between the time I accept your plea and the time of sentencing, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that?
Yes, sir.
Is counsel aware of any other promises, threats, or other inducements which have led to these pleas?
No, Your Honor. Thank you.
No, Your Honor.
And have I complied with the court rule?
Defense is satisfied.
Court will accept the defendant's plea to count 4 in the case ending in 5820. Counts 1 and 3 are dismissed. And in the other matter, will accept the defendant's plea to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14 or 15th District Court probation. Sentencing in this matter will be set for
5820. It's going to be April 28th at 9 a.m.
April 28th, 2026, 9 a.m. That's the sentencing before Judge Garwood. And in the other matter,
April 24th at 8:30 a.m.
April 24th, 2026, 8:30, before Judge Perry. Bond will continue.
Did the court dismiss counts 1, 2, and 3 on that case, or was it 1 and 3?
Just everything that needed.
Thank you, Your Honor. Appreciate it.
Thank you, Your Honor.
On behalf of Mr. Moot on the case ending in 1665.
Morning, Judge. Brian Bowling, Assistant Public Defender, on behalf of Mr. Moot in the cases ending in 5712 and 5718.
Okay. And are these all waivers or?
In case number 5718,
Yes.
the necessary witness did not appear in the claim for examination.
I would move, my understanding is that both charges would be dismissed here, Your Honor, so I'm moving to dismiss both charges based on.
People being unable to proceed, cases dismissed. That's on defendant's motion. All right, and the other matters, sir, you're waiving your right to a preliminary examination?
Yes, Your Honor.
You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, Your Honor.
You understand you'll not have that hearing and that you'll proceed to circuit court for further resolution.
Correct.
People also waive their right.
Due judge, and for the record, we did make a plea agreement prior to the waiver where Mr. Luke has been waived, almost respect to waive, and plea to the charge in 5712, that being possession of a narcotic thing. And then in 25F2165, we will offer a plea to larceny, $201,000 in circuit court as a global resolution.
That is my understanding of the people's offer as far as my case is concerned, and also awareness of the other case, and have discussed that with Mr. Moot, and he does wish to waive based on that offer.
That's my understanding of the agreement, Your Honor.
All right. Defendant having waived preliminary examination, he's bound over to circuit court in the case ending in 5712 on count 1, and in the other matter counts 1 through 3. As to the arraignment, gentlemen.
Oh, yeah, waive formal reading of the charges in my case ending in 5712. Your understanding is as for a pretrial thing.
Defendant having waived, oh, go ahead, Mr. Fred.
Acknowledge receipt of the information, waive formal reading, and stand mute as well, Your Honor.
Defendant having waived formal reading, standing mute to all charges, court will enter a not guilty plea to the 4 counts. Pretrial in these cases will be set for
May 19th at 1:30 with Judge Conkey.
May 19th, 2026, 1:30 before Judge Conkey. Bond will continue. Thank you.
Thank you very much, Your Honor.
One moment. Your name, sir?
Bobby Tennyson.
It's waiving.
Yes, Your Honor.
Sir, you're waiving your right to a preliminary examination?
Yes, sir.
You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yeah.
You understand you'll not have that hearing and you'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their right?
Yes, Your Honor. And if I may put that on the record.
Go ahead, yes.
So offered to agree not to add a offender notice in.
That's correct. That is correct, Your Honor.
Looking for my, I don't know, why do I not have information in here?
Thank you.
Well, Your Honor, I don't intend this as an insult, but I have a copy of the information.
No, I've got it now. Well, I've got the copy of the complaint, or at least the front one. All right.
Your Honor, my client waives.
Examination having been waived, defendant is bound over to circuit court on counts 1, 2, 3, and 4.
There's 6. I think there's 6 counts total, Your Honor.
Well, I have,
There's the drug counts, and then there's 2 counts of firearm.
yes, I see 6. All right. So it's actually counts 1, 2, 3, 4, 5, and 6. You're right. Got it. It's on the other page.
There's only 6.
Your Honor, I believe there may be, the information I'm seeing on file has 8 counts with
Except The one that I have has two of those counts by the magistrate count, what would have been the original complaint, counts 3 and 4, that there was a finding of no probable cause.
Gotcha. Understood. Thank you.
Yeah, the copy I got when I got my discovery, Your Honor, has 3. I have 6 counts total.
I'll update our file then. I apologize.
He's bound over on all 6 counts, Mr. Dawson.
Your Honor, we acknowledge receipt of the information, copy of the information. My client waives its reading, stands viewed as that a not guilty plea be entered.
Defendant every way.
After hearing multiple cases and reviewing the charges, the court ultimately allowed the legal process to move forward, sending several of these matters to circuit court for further proceedings. Moments like this remind us that many hearings may appear routine on the surface, but behind every case are serious allegations, legal strategies, and decisions that can shape someone's future. In this courtroom, the judge's role wasn't to decide guilt today, but to ensure that each case moves forward under the rules of the law. The real question now is what happens next when these cases return for trial and sentencing.
Before reading, standing mute, court will enter not guilty plea. Pretrial will be set for
May 19th, 1:30 with Judge Punky.
May 19, 2026, 1:30, Judge Coffey. Bond continued.
Your Honor, there is a co-defendant who was bound over to Judge Hammoud. I suspect I should just deal with the circuit court on that. I believe it was Judge Hammoud.
Yeah. Mario Taylor was bound over to.
I have judged this case in 2 places. This Judge Conkey.
I'll deal with circuit court, Your Honor.
Bond will continue.
Thank you.